Please remember that this is not legal advice and we cannot be held responsible for any potential inaccuracies in our video. In France, the principle of legal succession applies where a person's estate is distributed to their heirs according to legal provisions when there is no valid will. Legal succession is determined by various criteria, including the deceased's family status and the presence of descendants, children or grandchildren. Children typically have a significant legal claim to inheritance and receive a portion of the deceased's estate that is not freely disposable. This portion is referred to as the réserve héréditaire. The surviving spouse also has a claim to a portion of the deceased's estate, depending on the number of children of the deceased. If there are no descendants, the parents of the deceased may have a claim to a portion of the estate. In some cases, siblings and other relatives may be entitled to inheritance. The réserve héréditaire is a portion of the estate reserved for protected heirs under French law, namely descendants of the deceased, or in their absence, the surviving spouse. The amount of the réserve héréditaire depends on the number of descendants. If there is only one child, the réserve héréditaire is 50% of the estate. With 2 children, it's 66.66%, and with 3 or more children, it's 75%. A will allows a person to specify their own wishes for the distribution of their estate after their death. However, it's essential to note that there are mandatory regulations in France that ensure the availability of a portion of the estate to certain heirs. These are the réserve héréditaire and the quotite disponible, the available portion. If the deceased or the beneficiaries are foreigners or have assets abroad, complex issues of international inheritance law may arise. France has bilateral agreements with many countries to avoid double taxation and address inheritance issues. It's essential to be informed about the specific agreements between France and the home country. Tax implications. Inheriting real estate in France can have significant tax implications. There are different tax rates and exemptions depending on the degree of relationship and the value of the inherited property. It's advisable to stay updated on current tax rates and exemptions, as they can change. As of 2023, there is an exemption of €100,000 for children involved in inheritance. This exemption also applies to gifts, with gifts within the last 15 years being cumulated. In France, there is an exemption of €80,724 for the surviving spouse. This exemption also applies to gifts, with gifts made within the last 15 years being added together. As of 2023, for first-degree relatives such as children, if the inheritance exceeds the €100,000 exemption but does not exceed €550,000 after deducting the exemption, a tax rate of 20% applies. Relatives up to the 4th degree pay a 55% inheritance tax, while unrelated individuals pay 60% of their inheritance to the tax authorities. Legal advice. Due to the complexity of French inheritance law and tax implications, it is highly recommended to seek legal advice from a lawyer or notary who specializes in French inheritance law. This is especially important for foreigners who own or plan to inherit assets in France. An experienced professional can assist you in creating a will, minimizing tax consequences, and ensuring that your inheritance matters comply with French laws and international agreements. I hope you enjoyed my contribution. If so, please leave a like and feel free to subscribe so you don't miss any France-related videos. It's essential to consider the specific circumstances and family status, as the requirements and limitations related to inheritance law in France can vary from case to case. Therefore, seeking professional advice in a timely manner is crucial to ensure that your personal interests align with legal requirements.